and that injures you, you need to know what your legal rights are before it's too late. If you think it's too expensive to hire a lawyer, think again. We're going to talk about that. Most personal injury attorneys only get paid if they win or secure a judgment for you, so it's in your best interest to go see somebody and work it out. Call in your questions, the 31 Law Call number 256-536-0077. You can call in and be live on the air. You can also text us to that same number, and we'll have some of your texts tonight. You can also email us any day of the week on any legal subject. You send it to lawcall@waaytv.com, and when we get to a show on point, we will pull out some of your emails. We've got some of your emails tonight talking all about injuries. Will Lee is here from Timberlake, League & Brooks, personal injury attorney, so that covers what?
You know, everything from, medical malpractice claims, workers' compensation, which is, that's this area where blue-collar folks are out there getting hurt paycheck to paycheck. Yeah. Makes a big difference what your rights are. Those are the sadder cases. It's hard to get a medical bill, but 18-wheeler wrecks, I had a murder case here recently on, wrongful death and the civil side, murder on the criminal side. We don't do the criminal side, we do the civil side.
Yeah,
so like
big settlement
the civil
on
side.
Big judgment on that one.
We did. We got a $10 million verdict.
Wow.
But it was a lesser standard than the criminal. In the criminal, it's beyond a reasonable doubt. And in the civil, it's for the preponderance of the evidence, more likely than not. And it's, it's a sad case where, Ms. Capello was convicted of injecting her husband with insulin and sat on his body for weekend. And the Huntsville Police Department did a great job getting in there, finding the body, and convicted her. But anywhere, spring break's coming up. Everybody opening their pool liability. Sadly, those things, come up. Their spring break, a lot of kids down there acting crazy, getting hit by cars. It's just, sometimes it's a bit much to see a lot more of that and what to do and how to do it. So any type of injury, be brave, give us a call. 536-0077. I know a lot of folks have texted us about questions, so it's interesting. Try and get to some of those.
Yes, we've got some lined up. We also want to show you this video. This is amazing. So if you're going to be traveling this summer, not to scare you or anything, but this clip is worth...
surprising.
Out of the blue, hard to believe that this is even real because it looks like it's going to be something from a Fast and Furious movie. Okay, shocking, because you can't plan for something like this. There is no way if you're driving that black SUV and the driver is okay, so it was not seriously injured, must have been wearing seatbelts. You can't plan for something like that, something that's going to happen on the roadway. When you see that, is it clearly the truck's fault? It's not like the truck driver, the pickup truck driver did anything that we know of. What are you looking at to figure out, is there any sort of a case to bring of responsibility?
Poor guys in the black car, awful. White cars in their lane, really minding their own business, not swerving, not doing anything wrong. Under the law, you have a duty to, maintain proper control of your vehicle in your lane, all those things. So obviously that duty was violated. What fault? Was the car recently worked on? Is that something that was actually, they just got it out of the shop? Is it a new car?
Yeah.
Could it be anything from against a shop, if they did it at home and just did so negligently, or if the dealership worked on it, or if it was a new car, it's a products liability claim if there was a design defect or they placed that car in the stream of commerce in a defective condition under the Alabama Extended Manufacturer's Liability Doctrine, which is a mouthful, but basically they should have known it was dangerous, put it on the market anyway. Let's say there should have been a recall, didn't do it. Those cases are very expensive to trial. When you're talking about going after Ford, GM, all those type companies, the injuries need to be substantial to warrant the cost. So you often run into that. But you don't see as much as you used to, but there's still plenty of manufacturer defects out there that we're finding. You look into, the fin, all the PFAS cases, all those, mass tort type cases that are coming around the pike.
We've got an email question. I want to take the second email question. This one's from Kath and Dale. They wrote in, Kath says, I was in a rear-end collision. The driver who hit me was 17. She called her parents, who arrived on the scene in a matter of minutes. Does it matter what's on the police report? It said that I was slowing down and the driver didn't see me. We were at a red light. I was completely stopped. The cops seemed to know the parents. My insurance company's been terrible. I've been making all the calls to them. I haven't been able to go to the doctor yet, and my back and my neck are now in extreme pain. Any suggestions would be greatly appreciated. Okay, police report. Does it matter what's on the police report? If they were friends with the police officer and he's kind of tweaked the report to make it seem like Kath was responsible?
Well, Kath, the police report in and of itself is not evidence. It's, that's hearsay. You hear it on TV all the time. It's an out-of-court statement offered to prove the truth of what happened during the wreck. Now, in and of itself, it is not admissible. However, unless the officer witnessed the wreck right then, oftentimes that's not the case. So if the officer comes to the scene, he or she can document everything they see, and then that's evidence as to what the aftermath. Now, are they a reconstructionist? Are they qualified to be a certified reconstructionist? A lot of education to do that. Some are not. But they can testify what the nature of the vehicles were, anything they saw, all that physical evidence, and then the jury can actually make the determination as to who was at fault, what happened. But the officer cannot give his opinion as to who caused it unless there's a reconstructionist, type thing. So, that's one issue. The other issue is, from what you described, usually in a rear end, there's fault because you have a duty to maintain a proper lookout in your vehicle. So negligence, remember, you got to have duty, breach of that duty, failure to maintain a proper lookout, as a reasonable, prudent person would do, and then the causation of any injury or damage to your vehicle. And so if you've got those elements to bake a cake, that's a claim for negligence to at least get those damages. They mentioned that they're still hurting.
Yeah, neck and back pain, and she hasn't gone to see anybody about this yet.
We handle injury cases, and a lot of times people are trying to be tough, and I get it. Adrenaline's flowing, and they wake up the very next day super stiff and whatnot. Sometimes it's a herniated disc, sometimes you just don't know. But the insurance company on the other side, if you don't get treatment and don't evaluate and see where you are, there's an argument that, well, they weren't. So that's usually
can't have been really hard.
It's usually the playbook, and it's effective. And so you want to make an honest evaluation, find out how you're doing, because again, you have a statute of limitations of 2 years in Alabama, and oftentimes the shoulders starting to click after that wreck, and here we go. Then it progresses. You get a torn rotator cuff, needing surgery 8 months later, trying to do physical therapy. So we see that a lot, and it makes a difference in how the insurance company evaluates your claim and addresses it. Do you end up in court? Do you not? Those are things that, if the case is documented properly, you can show it's legitimate injury. There was negligence, not that someone is evil. All we're trying to prove is that they failed to live up to that standard. They were negligent, not that they have to go to jail or whatnot. And so compassion, sadly, is at an all-time low when you start talking about compensation for injuries. Usually jurors, they want to know how is this going to help anything? And so when you try cases, Sharon, you try them to a judge in the family court, right?
Right. We don't have a jury for family law cases, divorce and child custody.
And so in the civil cases, we'll have a jury. And so let's say it's you versus Mr. Smith over there. Well, we can't come into court and say Mr. Smith has State Farm or Allstate. We cannot.
Insurance.
We can't say that because there's a pretty big insurance lobby. And so that would be unfair, was the argument. However, if you have Blue Cross and Blue Shield that paid your medical bills, that evidence comes in. And so our insurance comes in, but the defense does not. So, and that affects jurors, and that's by design. And so it's a little bit difficult, to put that out there, because, a little lady on her way home from Sunday school didn't mean to run over and kill someone. That person's still dead. That person has children to be taken care of. And it matters the degree of fault in a lot of jurors, when they're issuing a verdict.
We've got Pete on the line with a question from Huntsville. Hi, Pete. Thanks for calling. What's your question tonight?
Well, I have a really bad back all the time.
Okay.
And I had gotten hit in 21. I got hit here on the 17th. But in 2021, I have a spinated cadaver bone from L1 to S1, along with bone marrow power spacers, false disc going down, plates down the front, posts down the back. Well, in 21, and they rebuilt my nerve system so I could walk again.
Wow.
So, but anyway, what happened in 21, like the back surgery and stuff I needed was $548,000. Okay, and because the government, I think, spent about $7 to $9 million on me. And anyway, they only had a $100,000 policy.
Okay.
I got nothing out of that one on 21, basically, because you got to get the medical bill paid, and that didn't even happen all the way.
But you got the surgery, okay? Yes.
So now I have this one, and my back is really hurting, screwed up right now. I've been seeing some other doctors and other stuff, and I'm going to be getting an MRI and stuff. But
so you had the previous injury, and now you've got
to what you can get just by how much they have in the insurance, whether it's a $50,000 policy, $100,000 policy, $300,000 or $1 million, whatever.
Right. So,
Is that what a person is limited to?
so unfortunately, it matters in Alabama who hits you. And so if the defendant driver has an insurance policy, because there's mandatory liability insurance in Alabama, minimum is $25,000. What if your bills are 30, 50, 100? That's the minimum. Most folks driving a vehicle are not independently wealthy that can pay that over and above their insurance limits. Now, if they're negligent, you can't recover over that. If they're wanton, drunk driving, speeding, those type of things, you can get over that threshold and maybe collect more than that. But again, there's bankruptcy. So a lot of people aren't driving around with an oil well strapped to the back. So it's difficult without insurance. The only thing you can do to protect yourself is have higher what's called underinsured, uninsured motorist limits. And basically, if the other driver has minimum coverage or coverage not enough to cover your damages, which in this case, if you were covered $100,000 and your medical bills were $500,000, you're way upside down. And the only way to protect yourself is to make sure you get underinsured motorist carrier insurance. I met with a poor kid last week. He's on a motorcycle. You know, he's trying to save money. I get it. And he got hit and he didn't have health insurance and it's just a disaster for him.
Oh, no.
And he didn't have a UM, and the other underinsured motorist, the other car didn't have insurance, and this kid's got a lot of help, medical bills, looking at bankruptcy. It's just a tough situation. So make sure to get that UM coverage. On your second case, you have a significant, what we call a pre-existing injury. It can be aggravated. You want to document what's different about it now than then. I mean, you were someone who could least afford to get hit with the medical injury, with the injuries you just described. And so was there what's called an exacerbation to that injury, thereby allowing you to make a claim? And is it different or is it the same old pain? And you ask the doctors, you need expert testimony. Remember, you can't testify as the causation of your own pain. A medical doctor has to come in and testify to a reasonable degree of medical probability or even certainty, but probability that the injury that you have or aggravation you have is as a result of this second motor vehicle wreck. And again, that's up to the doctors and up to any scans. Is there objective evidence? Is there an MRI, CAT scan, X-ray, anything to prove that? Because then it comes down to your word, and the insurance company jumps all over that if they can. And that's the name of how that battle goes.
We've got Chris on the line with a question from Brindley Mountain. Hi, Chris. Thanks for calling. What's your question tonight?
Yes, ma'am. We have had insurance, and a gentleman that we had known for years, he had passed away, and his wife was a widow there, and she needed money to pay her rest of her stuff off to afford her place. So we gave her $30,000 for like a lawnmower, four-wheeler, trailers, and everything as that. And then we proceeded to go to an insurance company and get insurance on different things there. And the gentleman that had been passed away for 8 years, he had insurance there, and they took one of the policies on the four-wheelers and moved it over and put it in my name, and then it come up stolen, and then we went to get a claim on it, and they said we had no thing of showing ownership on it, and they would not pay off on it. And I didn't think they could take, I don't know, I'm not a lawyer, I didn't think they could take a dead man who's been dead for 8 years, his policy, without even looking at the unit or any kind of documentation, and just write my name in it.
Okay, there's a lot
That's
there.
a lot going on.
Right. So, Chris, you were giving somebody some loans to help them to tide themselves over. Part of that were some four-wheelers or vehicles, correct? Okay, we may have lost
I think that's right.
But
I think that's right.
Somehow they got out of your name. So remember, each vehicle should have a title, and that title is, bearer of paper. Whoever has that is properly signed. If you have any type of receipt, any type of registration, and if the insurance company is not paying out and they're paying to someone else and you're not the rightful owner, that's one thing. But if you are, you have to prove it. So remember, it's, you can call the Alabama Insurance Department down in Montgomery to make a claim, to make a complaint, and hopefully they'll investigate to show that you are the owner. The other option is to sue for what's called breach of contract. Is you had an insurance policy, it was in your name, taken out on that vehicle, and somehow fraudulently it ended up in someone else's hands, and thereby you were lost that value. So you can recover under those if we can prove that it was in fact yours. Because remember, it's bearer paper. Remember there used to be checks. People would write things they call checks. My kids don't even know. And whoever has that, if it's properly signed, that's yours. And similar to vehicles, if it's properly signed, absent some other type of insurance.
Okay, we're going to take a break. We'll be right back answering your questions all about injuries. If you're on the line, stay on the line.
Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight we're talking all about injuries. Will League is here from Timberlake, League & Brooks. Injuries, so everything from car accidents, medical malpractice, dram shop questions. We got this text in from Tommy and Maddie, and they said, we take jobs bartending in summertime at resorts. Some of the fake IDs that these teenagers bring in are pretty good. How much trouble are they in if they mistake and serve alcohol to a teenager that had a really good fake ID?
Well, on the civil side, you can lose your liquor license. So part of it, providing alcohol, to the public, you got to have a license. And if you're found to violate that, if you're negligent, or even it could be strict liability, then you could lose that license, lose your livelihood. Now, for the personal liability of the bartender, or if it's reasonable, remember, in any crime, you have to have mens rea, which is intent. So was it negligence, or was there some sort of criminal intent to violate the law, will determine whether or not there's criminal liability there. And so, you want to be careful at the same time, as a restaurant owner, a dram shop case you mentioned, that if you overserve someone, let's say you serve a minor, that's contrary to the provisions of law. That minor leaves, the bar is liable. That minor leaves, hits someone, kills them, the bar is now liable under dram shop law if you've served alcohol contrary to the provisions of law. And so it's usually they're not personally liable, it'd be the establishment.
Okay.
But you probably get a pass, but it's going to be tough. If it's a repeat offender, the DA could charge it. It's in their discretion, and then the jury would make that determination if you meant to violate the law.
We've got Jewel on the line with a question from Huntsville. Hi, Jewel. Thanks for calling in. What's your question tonight?
Yes, ma'am. I would like to know, you were saying that the police is not the one that determines who is at fault in a car accident. Who is at who determines who is at fault in a car accident?
It's really if everybody can't agree. Sometimes there's arbitration. There's arguments between the insurance companies, and they've agreed to go to what's called arbitration, and they make that decision. If the parties get involved, then it's either a judge or a jury. The officer can go and testify as to what he or she saw at the scene, where were the vehicles, what were the witness statements. We can get those witnesses to come in and testify. But again, the officer doesn't decide unless he or she's a reconstructionist and can present that evidence. But again, the true decision is with the judge, or if it's a case with the jury determines who is at fault. But they'll give you the law, they'll give you the facts, and the jury's job is to apply the facts to the law the judge gives you. And that, in the end, is how you, if everyone can agree, that's how you find out. That's who makes the call.
We've got a question in from Tim and Kit. They wrote in, we've got plumbing issues with the unit above ours that's caused extensive damage to the unit. Is the owner of the unit above legally obligated to help pay for the repairs? Or is it
Is it a condo?
It's a condo.
Okay.
It's a condo, so that means they own it, right?
If you have that fee simple, if you have that real estate interest, and you were negligent and you caused that, the insurance is going to be fussing about it. Okay. Is it covered? Let's say the same faucet broke 6 times and you were supposed to put a valve in and you didn't, and that's something and you were negligent. You could be liable. If your insurance company could be liable, they may have an exclusion for idiocy or something that you did that was negligent. Not idiocy, that's not a legal standard. But let's say you did do something, then you could be liable outside your coverage to pay for the damage. Mm-hmm. And so it can get weird real quick if you don't have strong coverage. If you own that condo upstairs, you got to maintain it in a reasonably safe manner.
Got a text message in from Helen. She says, I've been helping my brother with medications after an injury. Hard to keep track. Am I going to have a medical malpractice case brought against me if I goof up the medicine?
I've heard claims like that, or people wanting to make claims like that. It doesn't seem like he or she is a medical provider and would be subject to the Alabama Medical Liability Act.
Okay.
And so there could be negligence, something like that. But in terms of actual malpractice, that wouldn't fit the definition. But again, if you take on a duty, let's say especially for compensation, if you take on that duty and then you give someone accidentally 10 bad pills and kills them, you could be negligent. That could be a problem.
Okay. We've got John on the line with a question from Lexington. Hi, John. Thanks for calling. What's your question tonight? Hey, John. Thanks for calling. What's your question tonight?
Pardon me?
Hi. What's your question tonight, John?
My question is about, I had a procedure done recently to check to see if I might had cancer. They're going to take a sample off my pancreas. I've waited about a month, and they finally called me back and said they lost my sample off only in my procedure.
Wow.
So what can be done? I'm lost. I don't know which way to turn.
On the medical side, go get another sample, get that in as quick as you can. On the legal side, is it malpractice? Did they fail to meet the standard of care? I would imagine the standard of care, and again, an expert would have to come in to testify that the standard of care requires them to keep up with your sample, and it's a breach of this standard of care if it was lost, right? So if that's the burden, then it probably overcomes that. The question is, what's the nature and extent of your damage? Is this delay? I hope it didn't cause you any problems, but is this delay in getting that? And then all of a sudden, the aggravation and pain and suffering of going through and having a sample taken out of your pancreas. So that's what a jury would determine is A, did this aggravation cause injury, or did this additional, what did you call it, were you injured? Did this delay cause any further, diagnosis of, God forbid, cancer? And then could it been helped after that? So there's several factors to go through, but number one, take care of the medical, and then sit down and talk to somebody who does medical malpractice.
We're going to take a break. Be right back answering more of your questions all about injuries tonight. Stay with us. touch with Will League, with Timberlake League and Brooks. The number in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And our very own Sharon Doviet, family domestic cases, 253-539-7337, SharonFamilyLaw.com.
Got a text from Liz. I was involved in a hit-and-run accident. I've got the tag number of the car that hit me. What rights do I have?
First, get a police report. Make sure you have that documented. Oftentimes, they can find him or her. And the only thing you can do to protect yourself is has full coverage, comprehensive, collision, uninsured motorist. You know, if they flee the scene, we had a case long ago, fled the scene, ultimately got arrested. ICE came and picked the defendant up and deported him back to Mexico. And in that case, you have to have underinsured motorist coverage. It's vital if if you really need it. So, really look at your policy.
Thanks for all your questions. We'll see you next week.